Today, I have a distinguished guest that I think most people in the hospice industry are going to want to listen to. Jonathan Porter is a partner at Husch Blackwell, one of the sharpest minds in healthcare enforcement law. He's a former prosecutor and assistant United States attorney. Jonathan spent years at the Department of Justice taking down hospice frauds or healthcare fraud schemes involving billions in false billings. Now he flips the script, defending hospices, home health agencies, health systems, and healthcare executives navigating the False Claims Act investigations. Chambers USA calls him a superstar, and clients say he always has the bigger picture. He also hosts a podcast called False Claims Act Insights and teaches white-collar crime at Mercer University School of Law. Jonathan, welcome to the podcast.
Tom, thanks for having me. This is exciting.
Yeah, it is going to be fun. All right, take us back to the beginning. Talk about the early moments in your career that got you into where you're at today.
Yeah. Thanks, Tom. The path towards where I am now, I always knew I wanted to help people. There's something about my personality where I really enjoy helping people. I didn't really know what that was going to look like. I didn't know that was going to be a lawyer, but I did find recently, my mom passed away a couple of years ago. We've been cleaning out some stuff from the house my dad lives in. And I found this book from when I was a kid that said that I was going to be a trial lawyer one day. And so I guess I knew what I was doing, from an early age, but yeah, that's how I got here.
That's awesome. So you went to Furman University for undergrad and then Emory for law. What drew you to law? What do you think? I mean, you started out as a kid thinking about law, but what really drew you into that? And then how'd you get to healthcare law?
Yeah, good questions, Tom. Yeah, with law, it really was an extension of my desire to help people with hard things. I like digging into hard things. I did a personality test when I worked in DC after undergrad. Between undergrad and law school, I worked in DC. I worked on Capitol Hill, and we did a personality test up there with my member of Congress that I worked for. And my personality test came back really weird. It said that my attention to detail in times of crisis is through the roof. And so what I do now is help people through times of crisis. So it actually works out really, really well. I went to law school because I love helping people with hard things. And so that's where I am. The healthcare thing was actually sort of bizarre. I had no intention of going into healthcare. I knew I wanted to be an assistant United States attorney. I met a guy when I was in law school who helped with Emory Law's trial techniques program. And, he was a federal prosecutor. He just raved about the calling that is being a federal prosecutor. And so I knew I wanted to go to the Justice Department. I knew I wanted to be a federal prosecutor. When I got there on day one, I had visions of, okay, I'm going to go stop, human traffickers and terrorists and, all these people. And I got to the office and they said, great, you're going to start in healthcare. And I had to Google like what the difference between Medicare and Medicaid was. So that was a DOJ decision to start me there. A lot of people started there and then moved into, violent crime or whatever. I loved it. I absolutely fell in love with healthcare. As a need for all of us, the weird role that it plays in our society where the government pays for a lot of it, but not all of it. How there's these interesting things in healthcare where you're not allowed to actually profit off of the full value that someone brings. So there's a bunch of stuff within healthcare that really spoke to me as important and nuanced. But DOJ told me I was going to be a healthcare lawyer. I fell in love with it from there, but I had no intention of going into healthcare before then.
Yeah, so you spent most of your career prosecuting doctors, pharmacists, executives, even a pastor for white-collar crimes. What did that work teach you about human behavior and decision-making under pressure?
Yeah, there's a lot of fraud out there. There's a lot of knowing fraud out there. People who go out and they say, I'm going to go commit all of the fraud. I want to commit fraud. Talking about like COVID fraud, the sort of text messages that we saw from targets' phones during the COVID pandemic, after the CARES Act was passed, showed people knew exactly what they were doing. There's a lot of people out there who want to go into the fraud world. I mean, you read about a lot of this on the news, people who intend to commit fraud. And there's a lot of that in healthcare as well. One of my FBI agents that I worked with a lot at DOJ, he was undercover once in this meeting of like marketers who were going to go door to door in a genetic testing scheme. And he's undercover pretending to be someone who's going to go door to door. and they're prepping all of the people to go door to door to swab cheeks and stuff for genetic testing. And the guy pulls him aside at the end and he said, all right, everything I just set up there was wrong. We're actually going to pay you this way. And it describes a paper swab thing. But he said, but we can't announce that because that's an illegal kickback. And so we're doing this other thing. I mean, that's someone who understands that he's doing something wrong. That's someone who understands that he's violating a federal law. There's a ton of people out there who know what the law is and intentionally choose to do the wrong thing. But there's also a lot of people out there, and I learned this as a federal prosecutor, there's also a lot of people out there who are trying to do their best and sometimes just get it wrong. And I think it's critical that we think about the difference between those two. On the one hand, the people who know that what they're doing is wrong, and on the other, people who don't know that what they're doing is wrong. They're trying to do well, and maybe they make a judgment call and get it wrong. So the key to me when I was a federal prosecutor was figuring out which cases deserve that big federal hammer and which cases don't. And that's what I love about my job is it's not necessarily always about right and wrong. It's about whether you knew that what you were doing was right or wrong.
Tell us about this pastor that did a white collar crime. You don't have to give names, but give us details around that.
Yeah. So he committed a good bit of CARES Act fraud. He invented a business, invented some fake tax returns. I think the first thing that he bought with his COVID loan was not in furtherance of any sort of small business, which didn't exist. It was to buy himself a Mercedes. I'm someone who has a great deal of faith, and I tend to treat my own pretty harshly when they do things they're not supposed to do. So that one really irritated me. But yeah, pastors should not invent fake businesses and buy Mercedes with the fraudulent proceeds.
Okay, let's pivot. So you were at the Department of Justice, you were prosecuting people that were committing fraud, and then now you've pivoted your practice, and now you're representing the healthcare community as they become scrutinized or disciplined against the fraud. So what made you change, and talk to us about that?
Yeah, so I did change from DOJ to the defense, but in my mind, I don't view it as changing sides or reversing course. When I was at DOJ, I prosecuted knowing fraud. The people who went out there and said, I'm going to go commit all of the fraud today. I know that what I'm about to do is wrong, but I'm going to do that. But what I started seeing was how the False Claims Act, which is a civil law, was being misused to extract really large settlements for conduct that was more in the realm of, you should have known rather than real fraud. And that concerned me when I was at DOJ, and it still does. So largely, Tom, what I do today is I represent healthcare organizations that find themselves under federal investigation, and most of them are in this gray area where the question is whether we knew that what we were doing was improper. And so the move itself has been great. I love Husch Blackwell. It's the number one health law firm in the country. We do a lot of things outside of healthcare law, but our health law team is spectacular in particular. Absolutely love the people I work with. Our clients are great. So I love the move to private practice, and I love the chance to get to represent people who are under federal scrutiny that I don't know that should be under federal scrutiny.
Got it. For sure. So right now, this is very, very prevalent. The vice president just suspended 447 hospice practices, 23 home health agencies in LA area, in the LA, California area. We're seeing tons and tons of this Operation Skip Trace. There's been tons of, millions and millions and millions of dollars out there. Thoughts around that? What do you do if you're a legitimate hospice agency that gets involved in this, or a home health agency that gets involved in this? So let's talk about first the policy and what's kind of going on, and then we'll talk about what do you do.
Yeah, I mean, there's a lot of pretty extreme fraud that's in the news, and this is actually not new. Several years back, there was a news story in California in particular that talked about how there were a bunch of hospices in California with 100% live discharge rates. I mean, thinking about what hospice is, you go on hospice for end of life, and if 100% of your patients their lives don't end, you've got some explaining to do. There's been a problem in California for a while. The issue is it just really hasn't been prosecuted. And so when something isn't prosecuted for a long time, word spreads that, hey, you can go make a killing doing this. It's the same thing with the CARES Act. So the reason the CARES Act got ripped off so much was because when the federal government rolled out Hurricane Katrina funding, and yes, Tom, I am old enough to remember Hurricane Katrina.
Me too.
The problem there was it really was not prosecuted all that much. There were some scattered, prosecutions, but there were a lot of people who knew that Hurricane Katrina relief got ripped off, and that emboldened people to rip off PPP, EIDL, all of these CARES Act things during COVID. It's the same thing in healthcare. When hospices are able to do things for a long period of time and rip off a lot of people, more and more people are going to arrive in that space as they hear, hey, this is a vulnerable program. And that's what's happening in California. So there's a lot of legitimate enforcement actions that need to happen in California. The issue, Tom, is that not all of this enforcement is going against those egregious actors. Some of this enforcement is going against legitimate hospices, legitimate home health providers, where they're doing things the right way. They just happen to be in a state where it's under a lot of scrutiny. And so the big deal here is making sure out of the gate, when you're talking with DOJ, when you get a lawyer and the lawyer's talking to DOJ, is framing this as, look at all these bad people over here. There's all these reports. There's all, Dr. Oz flying to Los Angeles to sit down with community leaders and talk about healthcare fraud in the hospice world. That's these people over here. We're not in that world. We're over here in this good world. Why don't you think about spending your time going after the 15 pop-up hospices that all register at the same address that's gotten millions of taxpayer dollars? There's a big difference here. And so it's irritating when DOJ responds to a crisis by lumping all hospices together or all home health agencies together and saying that we're going to go investigate everyone, when there's a set of really bad actors over here and a set of good actors over here. I mean, I think there's got to be a lot more effort to differentiate the good from the bad here.
And so how do they do that? Like, I can easily, plot every hospice agency in the United States on a map, and I can show you where those 15 or 20 or 50, or as Nick said, the YouTuber that went out there and, he knocked on all the doors and said nobody was there. And when they did answer the door, it was one person with a desk, and that was it. I mean, if I could figure that out, I can figure it out in seconds. So why aren't they using those tools versus going and scrutinizing everybody? And by the way, I've gotten a bunch of phone calls from hospices in California that said, hey, we just got a PPOE and they shut us down. They're not going to pay us. And now we got to prove our innocence, not prove we're guilty. And so they're going to go out of business, or they're going to lose money, and they're scrambling, they're panicked. They're, what do I do, Tom? And so they're getting tons of ADRs, they're getting tons of PPOE, they're getting letters of suspension. Why is it so hard for the government not be able to pinpoint, hey, these are all the guys that we know they're going to do fraud? They'd have 100% discharge rate, that kind of stuff.
Yeah. Why is it so hard for the federal government to figure it out? It probably shouldn't be. But one of the things that DOJ and its law enforcement partners have spent a lot of time thinking about is how to make better use of their data. A lot of this stuff's in the data. DOJ's got really good access to data. They've got a lot of programs in place to find problematic things quickly. And so a lot of this is making better use of their data. But Tom, I'll tell you, one of the big problems in all of this is that, at least on the civil side, the Justice Department's agenda is largely driven by qui tam relators, whistleblowers, people who file allegations of fraud under seal, and then DOJ goes and investigates, and sometimes it'll be years. And the disconnect here, Tom, is that qui tam relators really don't have much of an incentive to go after the fly-by-night pop-up hospice where all the money's been moved to some foreign location already. They're not going to recover anything there because the money's gone. So there's no use in spending all this time to get a lawyer and draft a qui tam complaint, get it filed under seal, meet with the government, give them all material facts, all of those things, if you're not going to get any dollars out of it. So the way this actually works is qui tam relators, their lawyers, are looking for legitimate providers, legitimate hospices, legitimate home health agencies, and the like. and saying, well, DOJ said that they're going to go after hospices in California or wherever. Let's go name key TAMs against these legitimate providers where they've got pockets. They've got the ability to actually pay funds at the end of this because they're going to want to get their attorney's fees paid, all of those things. And so what happens here is you get more action against the good guys than the bad guys, because relators lawyers know that they can collect against the good guys, and they know they can't against the people who've already moved their money to, Eastern Europe or wherever. That's the big disconnect here is that the incentives are a little bit off. That's not to say that the fly by night people, the DOJ doesn't find them. They should. But in the mix, it's the legitimate people who seem to get taken down because of the role that whistleblowers play in healthcare enforcement.
Wow, that one hurts. I mean, let's shut it off at least. I mean, we need to shut off the fraud, but because the money's already gone, they're not going to collect their fees. They're going to go fight everybody else that's trying to do the right thing. And really, what that's going to hurt? Who's it going to really hurt? In the big scheme of things, it's going to hurt the patient. That's a true, legit hospice patient that's being cared for, and you just shut off the funding for that hospice to be able to do more visits, more care, more chaplains, more social workers, more aides, more supplies, more meds. And so that's going to hurt. So if I'm an agency that just got a letter and they're going to shut me down and essentially return my billing off, and I got to go produce all these ADRs. ADR stands for additional documentation request. And I got to go send all this documentation in, and they're going to scrutinize every single patient that I'm seeing. What do I do? Like, if I'm an operator that doesn't understand this, what do I do? I'm no Jonathan, call you, right? It's the right answer, but you need to get a lawyer really quickly, and you need to get to work.
Yeah, Tom, I hate it when the answer is give me a call, because I really don't want to, blatantly market like that. But you really do need a good lawyer at that point. You need someone who understands all of these processes, who's gone up against the government before. I've had success getting payment suspensions reversed. Payment suspensions, by the way, on the federal level this was announced last year that these were coming. Kim Brandt, who's one of the senior CMS folks right under Dr. Oz, made an announcement last year saying that she's going to start exercising payment suspensions way more. And so this has been coming. This was not a secret. Those of us who are in the healthcare enforcement world knew that these were coming. The issue is, once the dollars are off, it's really hard to get a federal judge involved to get them turned back on, because of the way the standards work. It's almost it's really bad, because there's some stories out there about legitimate healthcare organizations where, when the dollars are turned off, if you're like a nonprofit or something like that, how in the world are you going to, stay in business for, a year, 18 months longer while you're fighting a payment suspension, fighting an investigation, getting your lawyers paid? I mean, that's a really dire situation to be in, but that's what that's what's happening for a lot of folks. Now, most of the payment suspensions really are going up against those fly by night, 15 hospices at one address situations, but it can be really dangerous for for a smaller nonprofit hospice that is in it for the right reasons. That's really, really dangerous.
And so, how long does that process take? From the time you get a letter to the time you get it turned back on, is it years, really?
Yeah, it depends. I mean, there are some court cases out there that show that it takes years. Sometimes you get lucky and you can get the right meetings and get it done quicker than that. But if there's a credible allegation of fraud, and it's a real allegation, you're up against it. The standards are pretty tough, and proving your innocence is not easy. And you have to think about the underlying investigation while you're having conversations about the payment suspension. There's a ton of leverage. The DOJ already has a ton of leverage in healthcare investigations. When you turn off the money for a community hospital or a mission-driven nonprofit hospice, it's really, really hard. It's really, really hard. So it could take a while. And unfortunately, DOJ knows that if it takes a while, they're getting more and more leverage, which is really not the way any of this should work, except for actual instances of, people going out and committing a whole lot of knowing fraud. But yeah, it's tough.
So what are the triggers, just thinking out loud? So if I'm a hospice provider, what are some of the trigger points? Is it live discharges, long length of stay live discharges? Is it eligibility criteria? Is it what's the things that you think the government's really going to look at in And what are the trigger points that really, would take a legitimate hospice and it's, really trying to do the right thing and get them into a situation?
Yeah. So, I mean, the stuff in the news should be the trigger. It's the 15 hospices that all enroll in the same day, and they're all involved. They're all at the one location, and so there's some pretty obvious triggers out there for the legitimate hospices out there. Tom, I have a feeling that most of your listeners are in the legitimate world. Um,
For
for
sure.
the legitimate folks, it is your sort of standard long length of stay situations. That still is something that DOJ looks at a lot. They've got some specific tools the DOJ can use, and the OIG has their own tools. But looking at long length of stay patients, so that I think is still one of the big triggers. The portion of patients that are on over a particular number of days. That is something that's still is a pretty good trigger. We could talk a lot. Tom, we probably do a whole other episode about whether that's the right thing. I tend to think that the amount of audits that are started by just having long length of stay patients has actually caused some problems in the hospice world, because I think reasonable hospices set up some extra reviews for long length of stay patients and are pretty quick to discharge them. I get why they do that for business purposes, but it's really hard when the fact that these patients get audited more than others, you're creating a business need for hospices to discharge otherwise really sick and dying patients just because they've been on for quite a while. But that's largely the way the enforcement regime works. Is a lot of times it's focused on long length of stay patients.
Yeah, I look at that in hospices that we work with all the time, and Nana's had her worst day. She's been told she's going to die in the next 180 days or so, right? It's not exactly 180 days, and we've convinced her to elect hospice, and she stays on for 180 days, and now we review her, and then Nana's not continuing to progress in her disease, and so now we're going to tell her we're going to discharge her off that. Like, she's had the worst time of her life. It's probably the worst 180 days of her life, thinking she's dying at any time, and now we're going to say, nah, you don't need to be on hospice anymore. And then, by the way, a lot of them go back in the hospital and die. And so now it's the worst kind of scenario. All right, let's talk a little bit about the requirement for reporting your data. So I read an article last week, and it was actually in the proposed rule that came out, that over 30% of the hospices don't report their data. So they take a haircut on payments because they don't report their data. Isn't that a red flag?
Yeah, I don't know, Tom. I mean, that to me is I guess I would need to know way more about that. So I haven't had any investigations where, part of the issue is reporting data. So I don't really know about that. I'm still on your last question, thinking in my mind, because I'm with you with those patients. And the issue is, dying looks very different to different people, and sometimes people defy the odds. And when they defy the odds, it doesn't mean that you're, no longer likely to die in the next 6 months. So yeah, I mean, it is. I'm with you on that, but in terms of reporting your data, I don't really know about that. I don't. I haven't seen something like that.
That's the HOPE and HCI data is the rule that, and so you have to submit your data, and it's long length of stay, short live discharges, GIPs, weekend visits, all those kind of things. And you're required to submit this data on every single patient. And if you don't, you get a 4% reduction and so the government decided, okay, we're going to encourage you to do this. We're going to give you 4% more money, or we're going to take away 4% if you don't. And 32% of the hospices don't report their data. And it's really easy to gather that data and report it. So to me, it's a red flag. Like, you should be reporting your data, right? Just like if you don't submit your OASIS, you're not going to get paid for a home health claim. Yeah, well, you got to submit your OASIS if you want to get paid. Just like Cole Sorensen, who runs my podcast, if he didn't expend his expense report, if he didn't turn it in, I'm not going to pay him for expenses. I mean, it's part of the job. So to me, it's a red flag. I'm like, come on, guys, you got to report your data. It's not that hard. And by the way, all the EMRs out there make it really easy for you to roll that up and submit it. So that, to me, that one, I just don't understand it. Like, if it's a government requirement, just like it's a government requirement to document how much time you spend in the home, why would you not document that? They want you to spend more time in the home. That's what they're required to document. I'd like to also thank our premier sponsor, Telehealth. Telehealth is used on a daily basis to figure out where doctors send referrals, as well as facilities. There's all kinds of data in the home health and hospice patients out of Trella. We use it a lot for acquisitions. So when we're looking at agencies that we want to be acquired, or helping agencies create de novo strategies or market studies, they look at it to figure out, do you dominate a community or not? how many Medicare lives are in those communities, and then how many hospice or how many home health patients are there in those communities. Trello Health also has a CRM product that allows sales and marketing to have clinical intelligence as well as market intelligence to steer them in where they're calling, making sure they're doing the right amount of calls, as well as documenting their sales calls inside their product. You can find them at TrelloHealth.com. I also like to thank our sponsor, IntelliTriage. IntelliTriage is a human in the loop, nurse first triage company that simplifies the triage function inside the home health and hospice community. You can reach them at IntelliTriage.com. Talk to us about Husch Blackwell out of Georgia. What are you guys primarily focused on the home health side, and then what are you primarily focused on the hospice side? So what's the business model? When I need you, I call you. What are you guys working on for me?
Yeah, no, Husch Blackwell, we're a national firm. We've got over 100 healthcare lawyers. We help healthcare organizations in just about everything they do from the legal side. My particular niche is representing those under investigation or in litigation against the Justice Department. Sometimes litigation against a whistleblower directly when it's a declined key tam, something like that. Some other part of my practice is proactive, helping people figure out how to do things in a compliant way. A lot of times that's advice around the anti-kickback statute or some complex compliance issue. But yeah, that's in general, that's what our team does. We've got a small number of healthcare lawyers in Georgia. We're all over the country though.
Yeah, so Georgia laws are different than California's, and there's certain things that are different everywhere. So I'm sure you guys have experts in all those different areas. You mentioned the anti-kickback. Explain that one to the listeners. Make sure they understand it. And how do you what are you seeing around the anti-kickback statutes?
Yeah, so this is the anti-kickback statute. For those who don't know, in every industry, in virtually every industry in America, you can largely profit off of your referrals, off of generating business for other people. Healthcare, Congress decided that should be totally different. There were some specific things that were going on in healthcare when the anti-kickback statute was passed. If you go back and read the legislative history, and I'm one of the few who's nerdy enough about this stuff to actually go back and read it, there were some very specific fact patterns that Congress was concerned about. You had what they called Medicaid mills, where you had think about strip malls, and you have all type of different healthcare providers and labs and DMEs and pharmacies all lined up in a row, and you had these runners who would apparently go through the entire mill, starting with a physician, and then going to a specialist, and then going to the DME and all these places, and getting money from each one. So for every patient that you brought in, you gave the runner a little bit of money. And they called those Medicaid mills. And if you read the legislative history, that's what the anti-kickback statute was designed to stop, was these Medicaid mills, people running patients through. That really wasn't illegal until then. I think it probably would violate some medical necessity stuff. But the Justice Department, I guess, told Congress that they need something else, and so they created the anti-kickback statute to solve that particular problem. And I think at its core, that's still the way the anti-kickback statute should work. I prosecuted a bunch of anti-kickback statute cases at DOJ, and they were all, hey, we'll give you X number of dollars for every, lab test that you order, or for every, back brace that you order. Those types of things are pretty clear. You get this amount of dollars if you order this particular thing. That's an anti-kickback statute violation if you do it knowing that what you're doing is wrong. The issue, Tom, is that the anti-kickback statute is being applied in some pretty unique ways these days. There's a case out of Texas right now where the government has said that a free nursing hotline can be a thing that is of benefit to a prescribing provider, which is that's a pretty big change from how the anti-kickback statute's been used over time. So there's a lot going on in the anti-kickback statute space where it's being used in ways that no one has ever used it before. There's been some pretty prominent trials recently where you have some, extravagant stuff that's going to people who are ordering a particular product, fancy trips, private planes, those types of things, Super Bowl games, college football championship games. Where it gets really interesting is what happens if you're not on a private jet. What happens if you're just getting someone to fly to your educational seminar at the Toledo Airport hotel? Where's the line? The Anti-Kickback statute doesn't say that Maui conference is illegal. Toledo Airport conference is fine. But the whole healthcare community has been going to the things like the Toledo Airport hotel in order to get their educational credit and learn about new things for a long time. But the law actually doesn't say that there's a difference between Maui and Toledo. We just sort of treated it that way. And so it's a really interesting area to practice in. I think the anti-kickback statute's one of the big areas that you're going to see a lot of enforcement in the coming years because it's being changed a little bit in how it's being used.
What about in the home health and hospice space? So I get the medical devices and the pharmaceuticals and, doctor, if you prescribe X number of these drugs, we take you on this trip or we take you to the Super Bowl. I get all that. But what about in home health? Have you seen any cases in home health or hospice?
Yeah, the way that gets scrutinized is the person making the eligibility determination, and there's specific ways that you should be structuring your relationships with people who are, if you're a hospice medical director or a certifying physician for home health, there's particular ways that you should be structuring those things. The way you should not be structuring it is you get paid if you admit people, you don't get paid if you don't. The way I went to trial. I think one time on any kickback statute case as a federal prosecutor, and I think I actually drew for the jury arrows with dollars going one way and referrals going the other way, or eligibility determinations being going the other way. It's a matter of are you paying your physician not just to do his or her job, but to arrive at a particular result. That's the type of situation where you get into some problems. And then you also have to think about your referral sources. So if you've got referral sources where you want to you want to make it really easy for them to refer patients to you, and so you're going to go and start bringing them a bunch of things of value. That's where you start to get in trouble. So you want to think about your certifying physicians. You want to think about your referral sources, and you also have to think about your patients. One of the big changes that I've seen in the anti-kickback statute is, there's this other law called the beneficiary inducement statute that a lot of people have been thinking about for a long time. Recently, DOJ has stopped going away from. So beneficiary inducement statute has all these carve-outs for various things that help patients, but the anti-kickback statute doesn't. So what you're seeing is key time relators and DOJ going not through the beneficiary inducement statute, but just saying, if you give things of value to patients, to home health patients, or to hospice patients, if you give them something of value, then they could be the person who receives the kickback. I'm putting that in quotations for those who are just listening to the audio. And so that's the way is you want to think about your certifying physician, your referral sources, and your patients.
So any examples of that you can think of, or someone's given somebody to, something of value to a patient?
Yeah, I've got some examples I can't talk about because they're my clients, but think about this. If you've got I had a case when I was at DOJ where a medical practice was advertising that if you came in as a new patient, they'd give you a $50, Amazon gift card, something like that. If you agreed to do X, if you agreed to have X procedure, we're going to give you half the money. That's a problem. I had a criminal case when I was at DOJ where a patient went into a pharmacy and said, hey, if you order all of this stuff that I don't need and that has not been prescribed, and you give me half the money, then I'll stay quiet. And so they essentially agreed to split the proceeds of healthcare fraud. If you didn't have that level of absolute healthcare fraud, then that's the type of thing. Giving a patient like a portion of the revenue, that's the type of thing that crosses a pretty big line.
Yeah, I'm sure. And should be punished under the law. I mean, it's integrity, all those things. Yeah. All right, let's talk a little bit about home health. So we talk a lot about hospice, but on the home health side, what are the things you're seeing on the home health side as it relates to fraud or anti-kickbacks? Or we talked a little bit about some of them, but Eligibility for home health, homebound status is a big one. I know that gets scrutinized a lot, but what are the things you're seeing in the home health side?
Yeah, enforcement and home health still very much around the core issues that you mentioned. I mean, it's eligibility, it's status, it's orders. Like we talked about earlier, DOJ is getting better at using data to spot issues. So they're looking at things like reimbursement per patient or reimbursement per encounter, and then reverse engineering the process to figure out why. Sometimes it's high. It's something like an unusually high number of therapy visits. Sometimes that's a concern with like a doctor and figuring out how the certifications are being made. So I don't think there's any one, I wouldn't say there's any one focus in the home health world, except that DOJ is getting better with data and figuring out why the claims patterns cause whatever issue they're seeing in the data. But I would certainly make sure that your physician, a lot of the sort of old ways that people were, that you saw a lot of home health enforcement of cloned notes where doctors were not actually making real determinations about eligibility. Those, I think a lot of people are smart enough to get away from that now. And to be honest, AI is going to help a lot of that anyway, where you can figure out the right way to accurately state how you're certifying your people. So eligibility and how you're wording your orders, those are some big ones. But I wouldn't say there's any like here's the thing when it comes to home health.
Yeah, most of the ones I see is the diagnosis code for the patient, that primary diagnosis code doesn't match the CTI, or they have, multiple research, 5 or 6, 7 research on a patient, which is your reimbursement per patient. You see those, your very little visits on, just barely breaking the LUPA threshold on all patients. Those are areas where, we see scrutiny around, as well as the homebound status. I mean, homebound status is a tough one. And that's one I wish the government would really look at. I mean, in hospice, you don't have to be homebound, but in home health, you do. And I always talk about the depressed patient that's sad, lonely, scared. Last thing we want that patient to do is be stuck in their home and not be able to leave their home. And so they really don't qualify for home health, but they do qualify for home health because they need someone checking on them and treating them and taking care of them. But we're now telling Nana, who's lonely, to stay in her home and don't go anywhere. So we're just going to make her more lonely. And then she's going to call 911, go to the hospital. And she's not lonely anymore. She's at the hospital, which is the worst place for her to be. Yeah, it's a wild time. I think it's getting harder and harder and harder. And the fraud itself, the California, Florida, Texas, all these places where you hear all the fraud, is just giving the industry a bad reputation. I mean, we're in the national news now. And by the way, most people that are 65 or older all watch the news at home and they sit in front of the TV and watch it. People that are my generation or younger or get their news from the, internet or, Twitter or whatever, X or whatever you call it now. But they're sitting there listening to it like hospice is bad. And that's unfortunate because it's the one thing that patients deserve. It's the benefit you've paid for your whole entire life. And nobody should die alone, and you should die under hospice and get the appropriate care and social workers and chaplains and aides that you need. And by the way, we cover all the medications at DME and care. And so you should be able to die in your own home and surrounded by your family. But it's such a scrutiny it's happening that it's kind of giving the industry a bad name. And I know the industry's trying to fight it off and trying to explain that, hey, the good guys are really doing the right thing, but it's pretty bizarre. All right, whistleblowers are growing in threat in both home health and hospice, filing a lot of cases. You deal with these a lot. Talk to me about those. What do you usually hear? Is it usually someone's telling somebody to do something wrong, or what's usually the case for these whistleblower cases?
Yeah, so like we talked about earlier, Tom, whistleblowers play an outsized role in healthcare enforcement because of these, because of their ability to launch a whole federal investigation. I would say, Tom, the most common whistleblower in my experience is a disgruntled former employee. Disgruntled former employees are a bit of a mixed bag to DOJ because they help get evidence of knowledge of wrongdoing within the organization. That's a really important thing that DOJ needs to prove. Remember, we talked about earlier about how it's not necessarily did you do right or wrong. It's did you know that you were doing right or wrong? A whistleblower can say, no, you understood that you were doing wrong. Here's the board meeting minutes or the email or the text message where you said that what you're doing was wrong. And so whistleblowers can help do that. But they're also jaded. So DOJ is typically careful with jaded whistleblowers who have an axe to grind. And so, like I said, they're a bit of a mixed bag. The best whistleblowers are usually senior employees who don't come across as angry. There's been some really successful whistleblowers who were C-suite executives who tried to fix problems within and then left when they couldn't. Those are really powerful whistleblowers, but those are rare. There was a whistleblower in Louisiana recently who was then a current employee of a hospice and who FBI then wired up after they filed the QTAM, wired up for an extended period of time to record meetings within the hospice. That hospice owner ended up not just with False Claims Act problems, but a criminal conviction. And so more and more, but I think that's pretty rare, is getting a current employee. Most of the time it's a former employee. More and more though, what we're seeing is non-employee whistleblowers. You're seeing patients file QTAMs against some sort of provider that, they think did them wrong. You're seeing competitors file QTAMs. I think that's an interesting development. But what you're also seeing is data mining companies serving as whistleblowers. And that's a bit of a new one. Just a couple of weeks ago, DOJ announced this program where they're going to vet data mining companies that serve as whistleblowers. It's really interesting. I don't really know they're doing a whole lot in the healthcare space, but they're doing a lot on the COVID fraud space. These data mining companies that figure out who's eligible and who is not. I think just as our technology gets better and better, you're going to see a lot more data mining companies that are going to file QTAMs and try to get profits from the government. As a taxpayer, I would prefer that the government invest in all of those, gee whiz technologies in order to find people that are committing fraud, rather than a, QTAM Relator that is actually just a data mining company doing all of that. But, it's an interesting development. It's going to keep people like me very busy, fighting off these data mining companies that are going to, go off and try to allege fraud. So, yeah, whistleblowers play a really big role, and they come from all forms. Yeah.
HCHB is proud to sponsor the Last Visit First podcast, which explores the complex issues faced by today's home health and hospice providers.
In the spotlight today, Chief Revenue Officer Hannah Pearson, explaining how HCHB uses technology to connect people.
One of my favorite phrases is relationship architect. The focus is about the client and building the right community, the right fabric of community around our customers, making sure that from the very bottom to the very top, they had a resource and a contact to reach out to with any problems, and that we could connect them quickly and expeditiously to the right resource. That's where the client success team was born, and we touch people at every level of the organization.
CMS just issued one of the most significant regulatory actions our industry has seen in years, and it's a clear signal that operational integrity, clinical documentation accuracy, and compliance readiness matter now more than ever in home health and hospice. At Maxwell Tech, we help agencies strengthen the operational and technology foundations needed to succeed in this environment. From clinical chart reviews and regulatory compliance assessments to workflow optimization, analytics, and operational readiness, our team helps organizations reduce risk, improve visibility, and operate with confidence. The agencies that will thrive in this next era of healthcare will be proactive, data-driven, and operationally disciplined. And that's exactly where Maxwell Tech comes in. If your organization is evaluating compliance exposure, preparing for growth, navigating acquisition diligence, or simply looking to tighten operational controls, now is the time to act. Contact the Maxwell Tech team at sales@maxwelltech.com to schedule a compliance and operational readiness discussion.
Hey, this is Alex with Steno Health. Our mission at Steno is simple: to improve the quality of life of the post-acute care clinician. Steno uses ethical, compliant AI to capture visits in real time and turn natural conversations into accurate notes and forms. We are clinicians ourselves, and we've designed Steno to never feel like an extra click or an extra burden in your day. The goal isn't to replace anything, but to support you in every aspect of your day so you can spend more time with your patients and still have the energy and freedom to be present with your family at the end of the day.
Yeah, the AI world is going to make this all super interesting too. I mean, we still haven't got to the bottom of, if the AI says this is the care plan, the frequency, the number of visits, and you follow that based on that, who's in trouble there, right? The nurse ultimately is responsible for, the agency is ultimately responsible for the care. AI is making a suggestion for them, but I think you're going to see some stuff around that as well. All right, let's talk a little bit about it. It's self-disclosing. So if an agency figures out they have a problem, And it's happened before. You go back and you look at claims, or you buy somebody, you start deep diving into the claims of them. You say, some of these claims are not probably right. We should self-disclose these. Like, hey, we made a mistake here. And you self-disclose to the government. Can you come out ahead in that? I mean, it's the right thing to do. It's what you're supposed to do. You should do it. But how does the Department of Justice look at those, or do they look at them differently than a whistleblower case or just a flat out fraud case?
Yeah, that's actually a really big hot topic within the white collar defense community at large. I'm told that the answer throughout most of the last 50 years was that self-disclosing was almost never worth it. There were all these stories of companies that walked into DOJ, self-disclosed some bad stuff, and then still got hammered just as bad as if they'd been caught red-handed. I think DOJ heard those stories too. And so in the last decade, there really has been a concerted effort to change all of that. So I'd say now the calculus is more self-disclosure friendly. To me, I'm going to walk clients through the pros and cons of each, but it depends on what the conduct at issue is. It depends on whether you've had, a noisy exit recently from someone who could become a whistleblower. Those sorts of things, how obvious the fraud is. Is this just a disagreement? Is this someone who, there's the person making the noisy exit, they're convinced that there was fraud, but a bunch of other people in the company, they don't think it's fraud. So it depends on a bunch of things, what the conduct actually is. And so, I think you've got to just walk the client through the pros and cons of the self-disclosure, but we're definitely at a spot where it makes sense for at least some people to go ahead and make a self-disclosure. I'll note that there was one case recently where the company self-disclosed not to DOJ, but directly to CMS, and DOJ gave them credit for that. That's not the worst idea ever, depending on your situation, is some sort of a self-disclosure, not to law enforcement, but to CMS. So there's some creative things that you can do that don't necessarily open you up to just a really catastrophic result that, allegedly happened, decades ago. So there's some creative things there, but I think it sort of depends on what situation the home health or hospice or whatever type of healthcare providers in. There's a lot of different ways that it could go. It depends on the facts.
Yeah, I heard about one, I don't know, it's been 5 or 6 years ago, where a physician was referring patients and he was part of an anti-kickback scheme, and they caught on to it. And the agency really didn't know this was going on. It was between him and a sales rep, and they discovered it. And so they self-disclosed. It was only 5 patients, but they self-disclosed it. And the government actually was very positive around it. They were like, "Hey, thank you for doing this. We're going to investigate it." And they went after the doctor, and they took the money back from the agency. Again, it was only 5 home health patients, but it was the right thing to do, was to self-disclose there. Because if you tried to hide it, or you brush it under the rug, then you're essentially proving like you're guilty as well. And so they were the ones that actually turned the doctor in and figured it out. And they fired the sales rep, of course, legitimately fired him, and it all worked out. But there's always a challenge around that. All right, artificial intelligence is starting to show up in clinical documentation and billing workflows across all home health and hospice. What new enforcement risks should operators be worried about right now around artificial intelligence?
Yeah, we could do a whole hour on just AI. I mean, it's a really, really big thing. There's 1,000 different AI enforcement risks in healthcare. On the simple side, ambient listening devices to generate medical records is becoming more and more common, but you've got to be careful about how you're prompting that. So someone at some point is going to use AI to shade notes to support particular types of eligibility. I think DOJ and whistleblowers would say that that's no different than, cloned notes. And I don't know that I agree with that, but it's certainly risky. If you say, look, I want you to, AI, I want you to listen to our encounter and then try to find a reason for how this person is eligible for X and Y and Z. That I think it presents a bunch of problems. Coding prompts is another that I see as risky. It's one thing to use AI as clinical support, catching things like appointments without a pre-auth, or when a hospice patient's prescription is about to run out, those types of things. But what happens when your AI-driven clinical support brings up a prompt that says, hey, could this patient benefit from GIP in order to run up payments? There's 1,000 others, but those are the ones that hit my mind first in terms of what could be really risky in AI with home health and hospice.
As a guy that's been in the AI business for a long time and, built Muse and all that, we've always said it's a clinical co-pilot, and we don't even use artificial intelligence in any of our terms because it's not artificial, it's real. And so if I'm asking a nurse to read a 40-page discharge plan from the hospital or a 40-page, documentation from the hospital, it's really not possible for her to read all that, understand it, and digest it and make a clinical decision around it. But if I use AI just to pull out the points of it and then use that to help in her documentation, make sure she followed up that, Nana has she's missing her right toe, or Nana has a wound here, or Nana has, this historical disease, or she has these allergies or these medications. That's a co-pilot. It's not giving you clinical guidance around what to do or how to do it with that patient. We're always still going to make sure that the clinician is involved. And all we're trying to do is serve up documentation to her to make it easier, summarize the note. And so I think that, in my opinion, is very beneficial. If you start using AI to replace a clinician or a clinician's decisions, then I think it becomes a real challenge. And so there's going to be a lot of scrutiny around it. The ambient listening side of it's really interesting to me because I think you can do ambient listening. We can do better documentation. We can do cleaner documentation. We can do faster documentation, make it easier, make it, have 100% grammatically correct, no spelling errors, those kind of things, read notes and those kind of things. But you still have to have a clinician review it and sign off on it and make sure that they're doing it. And rightfully so, right? They should. It's their name, it's their signature at the bottom of that page. We're just trying to help them go faster, better, and quicker. But there is going to be a lot of lawsuits around AI in the future, I think. And there's some people, I've seen some that are, they're auto coding, and they're 100% auto coding, and they're coding with upcodes and all those. It's it's one thing to say, hey, you missed these codes in your documentation. It's another thing to say, hey, here's how you code for better financial outcomes. I think it's an area that we got to spend a lot of time on, and there's going to be a lot of lawyers looking at it for sure. All right. So for all the home health and hospice leaders that are listening right now, the operators that are out there running agencies that have not overhauled their compliance programs in the last 3 to 5 years, what are the 3 things that they need to address immediately?
Yeah, good question, Tom. So one, I'd say figure out your highest risk patients. Is there a particular, homebound rationale that you're concerned with, or their, long length of stay patients? Figure out your highest risk patients. 2, I would say set up an extra layer of review for those high risk patients. We talked earlier about how that's sort of a standard thing that at least hospices do, is to set up an extra layer of review. I would say that does not mean that you are presumptively going to discharge someone who's a long length of stay, but just make sure that you've got your documentation in order. Like we were talking about earlier, Tom, it would be a shame if people thought that long length of stay meant you have to discharge them or should discharge them. I would just say, if you've got long length of stay patients or someone where you've got some concern on, eligibility for home health, just make sure you've got your documentation right. That's all your extra layer of review has to do. Just know that you're going to get the scrutiny and stand by your decisions. But that's the second one. The third, I would say, work with your medical professionals to make sure they're documenting things the right way. A lot of times when there's scrutiny about things like long length of stay or eligibility in home health, it's not necessarily about what was right and wrong. It's about what's on the paper. And so if you can make sure that your medical professionals know, hey, we're at this number of months or years mark, and we're, FAST score keeps changing, or the weight keeps dropping, make sure you're documenting the subtle things that continue to show progression of disease. Some, I think some providers might just say, okay, well, I say that they're eligible. I shouldn't have to show, gradual progression of disease. No, you have to show it. We're in an era where you have to show your work. It's like the old, middle school math test problem. Show your work. If you don't show your work, you're not getting credit. So just show it and explain how you're seeing gradual progression of disease. And that's not even a matter of, are they eligible or not? If you think that they're eligible, you just got to show that they're eligible by documenting things the right way. And sometimes you just need to train your medical professionals on how to do that the right way, so that what's going on in their mind is being recorded on the paper.
That's right. So they think Nana still belongs on hospice or home health. Make sure you're documented appropriately, and you should make sure your forms and documentation require that. Like, is Nana still homebound? Let's ask that question at every recert. Is she still homebound? Is she still really? I mean, if she's not eligible for the home health benefit. She may be ineligible for a different level of care. Make sure that we're documenting that correctly, and we should check ourselves on that for sure. And then you should create the compliance programs that review those charts and make sure that they're right. I agree with that. What separates a compliance program that actually protects an agency from one that just looks good on paper?
Yeah, good question. I mean, Tom, you'd be stunned how many people think compliance is just the right binders on a shelf. I think it seems like that was the way that healthcare compliance was at one point is, sign up for my compliance program and I'll send you all the binders. That's just not the way it works anymore. DOJ is full of people, of leaders who were, sometimes federal prosecutors, and they went to private practice or in-house with people, and then now they're back in the law enforcement role. They understand what the difference is between binders on a shelf and an actual compliance program with teeth. One of the things that I like to do with clients is to make sure that that when we're looking at our compliance program, that we've got examples of complaints that came in, and we're going to show what we did with them. That doesn't mean that you have to agree with the complainant every single time, but if you can show the steps that you took to actually investigate the thing and you made an outcome and you informed the person of what the outcome is, that's most of the job of a great compliance program, is to at least document that you're doing the work and you're coming to some sort of a decision. There are a lot of people out there who don't do anything like that. They don't have a log of complaints. They don't have a log of what they did in response to complaints. It's really hard for people like me to do their job when all of a sudden there's scrutiny, but you can't tell me what happened in your compliance program and why it happened. So yeah, having a log is a really good starting point of, here are the complaints that we received and here is what we did about them. But, a lot of people don't have the log. And sometimes they'll say something. This doesn't happen to my clients. My clients all have the log. But I'm told that other people in healthcare, they get to a spot where they say, okay, well, we don't actually have a log because we've never had any compliance complaints. We're perfect. That's a problem. Zero compliance complaints means that you're not making sure that people know how to voice their compliance concerns. So make sure that you actually are receiving compliance complaints from people, because if you're not, I think DOJ is going to say, well, you just didn't make it available in the way that you should have.
Yeah, it's amazing to me. And then we help a lot of agencies with QA and compliance. And it's amazing to me, like, how many people don't have, good follow through on all these. Like, you should follow through on every one of them. You should log it, and you're going to have problems, right? You're going to have that situation where someone had a bad day or someone said something that they shouldn't have said. And I always think back to an agency that I was working with, and it had a patient that we knew really well. And the nurse went in and said, I'm really busy today. I don't have a lot of time to spend with you. And the lady complained, and they didn't do anything about it, and they got in trouble for it. And I'm like, you have to respond to these. So you're going to have complaints. It's how you address the complaint, how you follow through, and the outcome of that complaint, and then the teaching around it, right? If we had that problem, okay, let's go talk to the nurses and, like, hey, don't be disclosing to the patients that how busy you are and how little time you have with them. That's not the right thing to do. They want you to feel like that they're your only patient. And so the education and training around when you have a complaint and how you take that throughout the organization is super important. And then make sure you document in the policies and procedures that clinicians follow of how to address these things. And then make it easy for patient. If a patient needs to complain, you want to know about it. If we're not doing the right thing for somebody, I want to know about it, and I want to address it, and I want to solve it and fix it and correct it. And that's the most important piece of it. I see that all the time. All right. If you could change one thing about how the government approaches home health or hospice enforcement, what would it be?
Yeah, it would be what we talked about before. It's sort of ignore the relator inclination to go after the deep pockets and instead go after the bad guys. A big portion of the way our system is set up, you got entire civil fraud division in DC. You got groups within every U.S. Attorney's office where their job is to respond to False Claims Act key tams and go launch investigations based on what relators want you to launch. I would say let's make sure we're going after the real bad guys first. We're spending a lot of resources in just responding to what relators want DOJ to do. I would say let's put the resources to going and finding all of those people that are in the news. The instances on YouTube, like you were talking about, Tom, where you go out and you see nothing there. It's just a UPS box, and they're supposedly running a multi-million-dollar healthcare organization out of that UPS box. These are things that I would, if I had the ability to step in and change things, I would say let's go do that and be less responsive to the relators and the relators' inclination to go after the deep pockets.
Yeah, for sure. It's, I wish we could spend all of our time and effort on those people and not less on the people that are trying to do the right thing. All right. You've sat across people at their worst moments in their professional lives, both as a prosecutor and a defense attorney. What do you want home health and hospice leaders to walk away from that conversation knowing before it gets to that point?
Yeah, Tom, investigations are common in healthcare, and they're becoming more and more common. That means there's a good chance that a lot of our listeners right now, that they'll be involved in an investigation at some point in their career in healthcare. I would say don't panic. The big takeaway to me is don't panic. Just because you're involved in an investigation doesn't mean that you've done something wrong. A lot of times it means that there's some gray area and a relator filed something that is, trying to scrutinize a decision that you did in a gray area. So don't panic. If you find yourself with a civil investigative demand or a subpoena in the mail or an agent on your doorstep, don't panic. Don't feel like you need to go explain yourself right off the bat. What you need to do before you get the CID is to do what you think is right and write down the things that you think are right. If there's a gray area, write down why you're doing what you're doing and make sure you're documenting on the front end. And then after you get that civil investigative demand or subpoena, pick a good defense lawyer to defend you, someone who knows what they're doing in this world, and then let the defense lawyer be the one to defend you. You don't need to go off and make a bunch of statements and try to explain yourself to someone before you get the lawyer. Start by getting the lawyer, and then let the lawyer be the buffer between you and the people asking the questions.
Yeah. Stop talking so much. That's true. Use your ears, not your mouth. All right. For an operator or compliance officer who just finished listening and realized that they may have some exposure or wants to take a look at their programs, or in the event of an emergency, how do they get in touch with you and in your team?
Yeah. Thank you for that. No, I appreciate the ability to put in a plug. So yeah, you can call me. You can call me. You can email me, jonathan.porter@hushblackwell.com. You can Google me, Jonathan Porter, Husch Blackwell, Jonathan Porter, healthcare lawyer, probably gets to me as well. But yeah, call me or email me. I'm happy to talk with folks about what their concerns are. A lot of people, I get a lot of calls from people saying, hey, I just heard about someone doing something, and we're doing something that is, tangentially related to that. Do I have a problem? I'm happy to talk through those types of things with people. I think a lot of things that people bring to me can be fixed with documentation on the front end. That should look a certain way. So I'm happy to walk people through what that looks like on the front end. I love counseling people about how to not get in trouble with DOJ. That's actually a really fun thing for me to do. A little bit less fun when I'm helping them respond to the crisis, but still something that I enjoy doing. So yeah, that's the way they get in touch with me. And yeah.
Well, Jonathan, thank you so much for giving us all your guidance and advice and direction and some of your historical stories. You were a special guest that we really wanted to get on the show, and timing unfortunately had to be perfect with all the stuff going on in California and Texas and Arizona and everywhere else. But we appreciate your advice and direction, and I'd advise the listeners, if you get into a situation, if you don't call Jonathan and his team, make sure you get a hold of the right lawyer and someone that knows what they're doing in the home health or hospice space and has some experience doing it. Thank you, sir, for coming.
Tom, thanks for having me. This was fun.
Hey, everyone. My team at Last Visit First here has let me know that a lot of you that are listening to this podcast haven't subscribed. So we just ask that you reach down and push the subscribe button. If you follow us, it helps us get better content and better guests on the podcast here. So please reach down and hit subscribe. We'd appreciate that. And please share this with any of your fellow colleagues that you think would like to listen to it. We'd love to continue to evolve our subscribership and the number of people that are listening. Again, you can find us on YouTube, you can find us on Apple, and you can find us on Spotify. You can watch the podcast or just listen to it. So we try to do all these in a way that whether you're watching it or listening to it, it's available to you. So thank you again for following us, and really appreciate you spending time listening to Jonathan Porter and the team here.